to be fair, the district attorney is no longer the district attorney under which many of those complaints occurred. Is that correct?
The complaints that were the subject of Mr. Rudin's article and his analysis occurred under District Attorney Robert Johnson.
Thank you.
Thank you. I'd like to now ask the District Attorney from Oneida County, Scott McNary.
McNamara.
McNamara, I got an extra Y here. Okay, thank you.
Thank you, Senator. As you said, my name is Scott McNamara. I'm the District Attorney of Oneida County. I'm also the President-elect of the New York State District Attorneys Association. And I am joined here today by the District Attorney for Bronx County, Darcel Clark, who is a former appellate division judge. I'm also joined with the District Attorney of this county, Albany County, David Soares. A few things that I just would like to mention in response to some things that have been said is, first of all, the presumption that there is no checks and balances on us is incorrect. We do have checks and balances. As a matter of fact, we have numerous checks and balances on prosecutors. First of all, the judges, starting right off with the trial court judge. They have the ability to suppress all of our evidence. They have the ability to discipline us. They have the ability, if it's an assistant, to contact the district attorney and ask that that person be punished, as the case might be. We also have the attorney grievance procedure. I would disagree with my good friend, Mr. Schechter, who we also serve on a commission together. The grievance commission does work, and I know that personally. Fortunately, I've never had a grievance against me that's been founded, but I have had people that work for me have that done. Now, the problem is that information is not made public, and there's reasons for that, and maybe that's something that could be fixed. Maybe if you knew what happens and that things that people do are addressed, maybe there wouldn't be this presumption that we have this totally unchecked system going on and that we are not held accountable for things that we do. In addition, judges can file grievances against us, public can, and just to explain the procedure, having been through it, and I'll tell you, the last grievance that was filed against me was filed against me because I would refuse to prosecute somebody. And I only say that to you because my main problem with the commission you're trying to create is this. This commission is going to have a chilling effect upon prosecutors doing their job. The most difficult thing that we do that causes people to really have problems with us and come after us is when we refuse to prosecute something when they feel that they're wrong. And the #1 tool in the criminal justice system to prevent wrongful convictions is prosecutorial discretion. Because when we look at a case and we say, I don't think the person's guilty, I don't think the evidence supports prosecuting this person, and then you end up with a grievance like the last one I had because I wouldn't do that. So then what's going to happen is we're going to spend the vast majority of our time defending every judgment we make, trying to make the system better. And do you want us spending all that time defending every judgment call we make? Or do you want us doing things like DA Soares is doing, that I'm doing in our county, doing second chance programs, doing conviction integrity units, trying to make better relationships with the community that we most affect? I mean, those are the things prosecutors should be concentrating on, not coming before a commission defending every judgment call we make because somebody disagrees with us. And when you do get a grievance filed against you, we do have rights. We have the rights like anybody else. We have the right to defend ourselves and to have an attorney present. That's not wrong, that's fair. We have the right to due process. We should have the right to know what the burden of proof against us is. And you know what? Just like the people that we deal with every day, people are falsely accused. And people have the right to defend themselves. And that concerns me when my good friend Marvin says, that we show up with attorneys. Well, I would hope we do. Just like when we put a case in the grand jury and the suspect comes to testify, they should have an attorney present with them. That's not only a right, I think it's a necessity when you're dealing with somebody's livelihood. So, I share with you that, but the procedure is someone files a complaint, we do have the right to respond to it. You have the right to respond, and then you tell them what you did, and then they decide at that point whether or not they want to do a further investigation. And if they do a further investigation, then they call you in front of them, you will have to testify. So there is a procedure in place, and I can assure you, and what I would ask, and we've talked about this before, Senator, I would ask that we do something to try to determine how many people are disciplined. Because I don't think any of us are proud, but people make mistakes regardless of what job they're in. Prosecutors make mistakes. And there's a big difference between a mistake and misconduct. And that's something that needs to be looked at. And are we going to be answering to every mistake we make versus the egregious things that, that do need to be addressed and that we are addressing? This organization, we have actually filed grievances against prosecutors that we thought needed to be investigated. So we're doing a lot of things at our level, including, and as I had told the senator one time when I met with him, the best thing that this body of government ever did, by far, was create NIPD. Because before that, prosecutors didn't have the training that we have now. We didn't have the ability to come together and work together. When I started in '92, I didn't know the district attorney in Bronx County. Not only do I know her now, she's a friend, and if I needed help, I could reach out to her. So because of what you created with the Prosecutor Training Institute, a lot of the things that have happened in the past won't happen in the future. So I just ask you to consider what we have and consider what the Justice Task Force is doing and what their recommendations are before we create an entire brand new body of government to oversee something that is actually already being overseen. Thank you.
I'm violating my own rule. I just got to follow up because this is the crux of the whole situation. With respect to the grievance committee, I'm not aware, and I've asked everybody to tell me of a situation where a grievance committee, and they're different all throughout the states. Depends on what the local talent is in that locality. But can anybody give an example where, in view of all the cases that have been reversed, in view of all the people who have gone in jail that unjustifiably, one case with the grievance committee has seriously disciplined a district attorney?
There was one out of Queens many years ago, a man named Stewart, who many years of abuses. He finally crossed the line and lied to a judge in open court with respect to the whereabouts of a witness. He said he didn't know where the witness was. As it turned out, he did know where the witness was. He was eventually brought before the grievances committee. And I don't know if he was disbarred. He certainly was suspended from the practice of law. And a few years ago, he reapplied to come back into the legal profession. That has not yet been granted. That's the case that I know of.
Okay, excuse me 1 minute. We have an anxious member of the audience that's standing up. Would you identify yourself?
Robert Masters.
And why do you rise, as a judge would say? Why do you rise?
I'm an executive assistant in Queens District Attorney's Office.
Okay, maybe you can be with the next panel. Your DA is right there.
I think I can inform, my DA is not here. I can inform that case, actually. That grievance occurred as a result of our office making the grievance itself. When we were the ones who investigated, found the problem, recommended the grievance discharge Mr. Stewart.
Okay. And that's it, huh? That's the only example we can get? That's number one. Number two, there's something going on in St. Lawrence County now. The prosecutors are obviously aware of that case. I'm not going to get into the details. It's not really necessary. It's my understanding that the current president of the DA's Association actually took some action in order to get a public official to do something about what's going on by the DA in St. Lawrence County. Can you explain to the group here what the present president of the DA's Association did?
Sure, absolutely, and I think it emphasizes the fact of how the system does work. First of all, she is presumed innocent at this point, and I can't emphasize that enough, as every defendant we deal with every day is presumed innocent until they're found guilty. But based upon the allegations that were being disseminated mostly through the press. The District Attorneys Association, through our president, Tom Zugaby, we personally sent a letter asking that she be investigated by the grievance committee. So there's a perfect example of the committee, we doing what we have to do ethically. There's an ethical rule. If we believe that there might be something going on that's unethical, we have to report it. And we did that, and it's being investigated. And you know, and I have the utmost confidence that it will be properly investigated, and they will, if they find something wrong, she will be punished according to what they feel is the appropriate punishment. In addition to that, I think she's an elected official. She's going to have to face the public too. I mean, you know, there's something too that I think sometimes gets lost in the mix. When prosecutors don't do a good job, and when they are very controversial, they usually don't get reelected. And I mean, the public, especially today, with you know, the social media that's out today, trust me, if you ever want to know how bad you are, you can just Google your name.
We run every 2 years, okay?
I know.
And I've been the subject of many articles in all the papers. But I guess my question is, why wait 4 years for someone to continue conduct? And let me make one other point. There's an individual who submitted some testimony, and I'll make it public. Her name is Karen St. Hilaire. She was the county manager up in St. Lawrence County. I won't get to the details of her complaint, but she made a complaint against the same DA in July of 2014 with the Committee on Professional Standards. Never heard a thing as of today. She then went, and this is some of the early activities that are now becoming public. She then made a complaint to the Public Integrity Bureau of the New York State Attorney General's office. She was sent an acknowledgement that they had received the complaint, assigned a case number, and has had no response other than that, and that was 2 years ago. So I guess I understand what you're saying, and I'm just trying to find the proof that the current system works at the present time, and that's what I'm looking for. And if we can now go to, I'm not sure who's who, but is it Kian Katabi?
Kian Katabi, yes.
Yes. Could you please testify now?
Good morning. My name is Kian Daniel Katibi. I'm an honors graduate of New York University. As well, I hold a degree from the Benjamin N. Cardozo School of Law. Recently, I passed the New York State Bar, and my application for admission as an attorney to New York State is currently pending before the First Department. Having said that, while I'm pleased with my recent accomplishments, at this stage in my life, I would have far preferred to have already had an established career path. One of the reasons that is not so, if not the only reason, is that from 1999 until 2008, I was incarcerated in New York State as an innocent man. Those years were accompanied by criminal proceedings attached to the head and the tail. Please allow me to give you a little context. In 1998, 2 young men were stabbed outside of a local bar in Pleasantville, New York, Westchester County. That's my hometown. The men were so intoxicated that they did not know who had stabbed them. Over the course of the investigation, what had been ultimately a faulty case had been handed up to the District Attorney of Westchester County. How and why the prosecutor in that case decided to go ahead with and try the case is beyond my realm of knowledge or understanding. However, there were certain actions. Let me get right to the point for the purposes of this hearing. In 1999, before my trial, the district attorney had agreed to a consensual discovery request from my defense attorney, which meant that they would simply consent to giving over everything I was allowed in discovery, which included the victim's medical records. And they agreed to do that by a certain date. About a week before trial, much of this was not handed over yet. A few days before trial, the medical records of the victims arrived in my defense attorney's office. He noticed that a few pages were missing, so he subpoenaed the medical records. When they arrived the morning of the trial, the front page of the victim who I was being tried for his assault, the front page of his medical record indicated that he had stated upon admission to the attending nurse, "I had 14 drinks, beer and whiskey. I don't know what happened. I wrestled with some guys." Now, this was pretty important information for my case, my trial, where no one had actually said that I stabbed anyone, and where the victim had said that he'd already been on record testifying that he had only 1 or 2 drinks, he recalled what happened, he didn't wrestle with anyone, and that it must have been me that stabbed him because I was in the area. Certainly this is good information to withhold from the defense. Having arrived the morning of my trial, that information, we were unable to locate the attendant nurse to get her to testify for trial in time, and that evidence never made it before the jury. I was ultimately convicted. I pursued appeals. I reviewed my records. I studied the records, and I found there was allusions to statements being made by certain witnesses. I filed many Freedom of Informations against the district attorney. I pursued Article 78 motions and appeal to get them to disclose the criminal file that I knew they had. I had the record there, which statements were made. They resisted every step of the way. Every single response that they said to me was, in the response, even to the court, was, "We reviewed the record and the police file. There's nothing here to indicate this. We reviewed it very thoroughly." This went on for years. Finally, in 2008, after confession of the true assailant, I was granted a 440 hearing in Westchester County Supreme Court. I remember the morning of the hearing that summer in 2008, I went before the court in Judge Zambelli's office. As I went in, she made an oral decision on an order for discovery, and she, right then and there, ordered the district attorney to disclose the file, including the police file, for the purposes of the hearing, which you would assume would be very relevant to this case where there's a colorable claim of my innocence, having had the confession of the true assailant. At that time, the district attorney got up and stared right at the judge, is somewhat trying to be convincingly saying, "Oh, the file is missing, it's gone. We don't have the file, it can't be produced, and it won't be produced." I wasn't the only one surprised or in doubt. Actually, at that moment, I recall to this day Judge Zambelli taking off her glasses, getting red-faced, and storming out of the courtroom and saying, "Go check while we're on break." No file appeared. I went on with my hearing. I guess it's just by the grace of God or sheer luck that the confession, along with other evidence which was adduced at the hearing, my conviction was ultimately reversed, and I was exonerated. Throughout my appeals, I had consistently, my defense was, nobody had stated that I did the stabbing at trial. This is not sufficient evidence for guilt. Each and every response from the district attorney in their papers, in their briefs, in their letter motions was that 2 people had identified me as the attacker. It's simply not true. There's nothing in the record to indicate that. And I can tell you, it's hard enough to win an appeal, the presumption being against me after a criminal conviction, without the district attorney misleading and giving false or misleading information in their responses. You know, I have to question at this time whether they really, throughout this whole ordeal, had thought that I was guilty or not. A lot of their actions indicate that simply they may have not have cared at all. I know my time is limited here. With that said, I would just like to thank you for your time.
Just 2 very quick questions. Was any disciplinary action or any action taken against the district attorney?
No disciplinary action was taken against the district attorney, sir, to my knowledge.
Okay. With respect to, and I don't want a number, did the state of New York have to pay any money to you for the wrongful conviction? I don't want a number.
I went through a trial, and in 2010, the Court of Claims, a bench trial, the court had found that I had proved by clear and convincing evidence my innocence and that I had not contributed to my conviction, and an award opening the door for liabilities. Ultimately, there was a settlement.
Okay, thank you very much.
You're welcome.
If we could now go to try to keep this balanced, I believe we have,
Excuse me, Senator. I
Yes.
just wanted to note that we've been joined by Assemblywoman Helene Weinstein,
Yes.
Chair of the Judiciary Committee.
Bennett Gershman, Professor of Law and former Manhattan Assistant District Attorney.
Thank you.
Could you grab the mic and
Okay. Thank you, Senator and panel, for inviting me to be here today. When I started writing this treatise on prosecutorial misconduct about 30 years ago, I researched hundreds of cases where prosecutors had engaged in serious misconduct, and I noted that these prosecutors weren't disciplined. And I said that at that time, and it struck me that this is a illogical situation. I mean, prosecutors wield more power than anybody in our society lawfully. They can deprive people of their lives, their liberty, and they can destroy people's reputation. And there really are, as I found, no consequences. There are no consequences. I can't think of any other official in our society, any other person in our society who commits violations of rules and there are no consequences. Now, I wrote about it, and other people have started to write about it. And so I think it's incontestable that prosecutors in New York State do commit misconduct. We're not talking about, as District Attorney McNamara said, we're not talking about mistakes. We're not talking about errors in judgment. We're not talking about refusals to prosecute. We're talking about blatant, egregious, flagrant misconduct. And it happens a lot. Now, I think the vast majority of prosecutors in this state are honorable people. And I think they would welcome a commission. Because when a prosecutor violates the rules, as so many of these prosecutors have done, it taints everybody. Now, you know, when Mr. McNamara said there's going to be a chilling effect on prosecutors, they said the same thing when the Judicial Conduct Commission was created. Chilling effect, the judges aren't going to be able to do that. You know, no, that's not right. Prosecutors will vigorously do their job fairly, ethically, and that's all we care about here. We care about ethics, and right now it's incontestable that prosecutors are not held to account for their misconduct. In the Rudin article, he subpoenaed records from the DA's office in Queens and the Bronx, over 70 cases where judges found serious misconduct. The DA's office didn't want to say who those prosecutors were. Finally, the judge in discovery said, give them the names. They got the names. None of these prosecutors, none of them were reprimanded, were brought up on any disciplinary charges at all. And in fact, when they got the records, the personnel records, you know what happened to these prosecutors who committed misconduct? Yes. They were given bonuses, they were given raises, they were promoted in the office. Can you imagine that? How does that really make the average person feel who has been sent to jail for 25 years, who's innocent? New York State ranks second among all the states in terms of exonerations of the wrongfully convicted. And the prosecutors, in about a third or close to a half of those cases, the prosecutors contributed to those wrongful convictions. That's fantastic. That's just hard to really imagine. And it's hard to imagine that prosecutors are not held to account. I think I'm going to stop right there. I laud the courage of...
So, Professor Gershman, I wanted to ask a question to Mr. Tembekian, because I still didn't get a full answer to my question that I asked Mr. Schechter. So what I want to know is the situation of a judge prior to this commission that was formed in 1970, whatever. What was the disciplinary proceedings like for judges at that time? Was it similar to what we are hearing in the testimony that's being given today?
Yes, in the sense that the authority to discipline judges was diffused. It was spread out among 5 different entities of the court system. What was different was that the judicial disciplinary structure before there was a commission effectively had no staff, and it was ad hoc. If a complaint was made and it got to the court system would assign people to investigate them. But
this was on the Court on the Judiciary, which was the first step, right? of attempt to rein in bad
Yes,
judges?
and also the appellate divisions had authority, but they didn't have a staff, they didn't have an office that actually was responsible for conducting these investigations. If a complaint on a lower court judge made its way into the court system, a staff person within the court system was essentially
But
assigned
even prior to that,
investigate.
was it just the disciplinary commissions of the disciplinary committees of the appellate divisions that would discipline judges just like other lawyers? That's really what the heart of my question.
It wasn't the grievance or the disciplinary committees, and in fact, as you know, there are 2,000 judges in New York State who are not attorneys. So they would not have been under the disciplinary committees in any event, because the disciplinary committees are literally limited to enforcing the rules against attorneys. But judges were disciplined, if at all, and there were relatively few before the commission was created who were disciplined either by an appellate division or by the court on the judiciary, not by the grievance committees. But the structure was diffuse, it wasn't uniform within the departments.
Thank you.
We now ask David Soares, DA of Albany County.
Thank you, Senator. First and foremost, Senator, thank you very much for this opportunity to be here and to share my thoughts personally, as well as my thoughts as a member of the District Attorneys Association of the State of New York, an organization that I am proud to be with representing. I come here today with a full appreciation of where we are right now, not only in the state of New York, but where we are right now in this country with respect to criminal justice issues and criminal justice reform. There's a lot of discussions going on at the federal level about sentencing reform, so many different issues. And there's a lot of effort and energy being placed in changing the criminal justice system, a change which I think is very necessary, as we've all seen and we understand the impact that the criminal justice system has on certain people. The one thing that I've always marveled at ever since becoming a district attorney myself is how little attention is actually paid to county district attorneys. We do have a lot of authority. We make very important decisions. And if you want reform, then generally speaking, that reform comes from local communities. We all practice law. We all use the same penal codes. We all use the same criminal procedure laws in the state of New York. And based upon the demands of our communities, we practice it in a way that reflects the wants and needs of our communities. Albany County, I can say Albany County is a very progressive community because that's what our constituents demand of us. Albany County, we have a unique relationship with our communities because that's what the citizens of Albany County demand of us. And I say this to you because I think, for me personally, being here as well as a representative of DASNY, I'm not here to tell you what you should do. I'm not here to scream or bang a table, and but I am here to provide you with my own personal experience as a sitting DA as to what I've experienced in my 3 terms here in Albany County. And I offer the words that I'm going to offer here today as just some guiding posts for you to consider as you proceed down this course in arriving at your determination. Ultimately, if there is a commission that gets to oversee the work that I do, that's a decision that's going to be made by the same people who've elected you that have elected me. And we have
May I correct you, Mr. Soares, that this commission is not intended to oversee the work that you do. It's a commission on prosecutorial conduct, and it will only take up complaints that's brought to the commission based on what happens in conducting your job. And not just, there has been a lot of emphasis on the district attorney, but this commission will be responsible for disciplinary issues pertaining to all prosecutors, those people who you appoint as
district attorneys, because a lot of the problem that exists comes from those working under your supervision and authority that sometimes are not facing the disciplinary action that is necessary for their conduct. Thank you.
Okay. Well, Assemblyman Perry, then I stand corrected as to what the focus of the commission is going to be. And I guess without getting into a question and answer segment back and forth, I would first ask you to consider whether or not the complaints that are going to be filed, whether this commission is going to be entertaining those complaints as investigations are going on, as criminal prosecutions are going on, or after the completion, termination of those investigations and prosecutions. That's something that has to be seriously considered by this body as you move forward.
I think the answer to that is it'll be modeled after what the judicial model is, because I'm sure that judges still continue their trials and continue their work during the course of their investigations, but I would leave it to Mr. Tembekian to tell us otherwise.
Okay.
Generally speaking, the Commission on Judicial Conduct does not involve itself in matters that are pending, but there are exceptions, and there are logical exceptions. If the complaint, for example, is that the judge is delaying unduly, and that delay stretches into years, and if we wait until a decision, which may never come, before we ask the judge what's taking you so long, it would be self-defeating. But generally speaking, where litigation is ongoing, we tend to step back.
Thank you.
So that certainly is an answer. Check that one.